A very, very warm good afternoon, good evening to each one of you. I'm grateful to IBC Laws uh, for having me here for the session on the IBPI changes that has happened in the last 5 to 6 months. So there have been quite a number of changes, and I think the biggest weapon that, as an individual professional, that we should have is knowing the changes and using them well. So it's always starts with knowing the changes, because unless we know them, of course, there's no way that we can use them. And gone are those days, which we also are very much aware as insolvency professional and as lawyers, or as even as practicing consultants. For example, you will find some changes that is there to be done in a resolution plan. How is the resolution plan to be presented to the NCLT, etc., even if the resolution plan has got passed maybe about 3, 4 months back by the COC and is before the adjudicating authority. So, what are the changes still that is required to be done? There are certain such nuances which one has to know. So, IBC Laws has also been playing a very great role, a very constructive role in bringing very instantaneous changes to us by way of, not only by way of their WhatsApp channel, but also by way of their email and the circulars, and by periodic publications that they come out with. So I am always very impressed by the way they work. And I also thought it appropriate that, rather to come up with what the changes are in the past 1 or 2 months, IBC Laws requested me that if we can take the professionals along and tell them that what are the changes that has happened since 14th of October, because since 14th of October there have been some n number of changes which are pretty critical for our working. So we tried to put them together, and here I am with all of them. I just quickly to introduce myself, I'm CS Dr. Mamta Binani. I also am the first registered professional, insolvency professional of the country, of India. And I also brought the first resolution, and that's only by grace of God, of course, to the country, which was in the name of Synergies Dure Automotive Limited. And since then, I've been working as an insolvency professional, and I've been the past president of the Institute of Company Secretaries of India. Now it is known as former president. So, just to be right technically, I've been the former president of ICSI in the year 2016. So, in this year, 2016, this law had come in December 2016, this law got enacted. And for the entire 2016, I was there as the president. So, I had the opportunity of seeing it from close quarters. And so maybe that has also been one of the reasons why, I got very intrigued and very interested in this law, because I saw that it is something to do a lot with resurrection and restitution. And that is where, as a women also, we always have this inclination towards giving the process of rebirth to a ailing company. And when I saw how the law is panning out, I really became very interested in it. So today, from IBC Laws, we bring forward to you what are the IBP amendments and updates since 14th of October 2025 till 6th of March. So till 6th of March, there has been quite a number of them. I will give this presentation to IBC Laws just in case if they wish to circulate. So I will give it to them. Rest I leave it to them. Now I'll request all of your good selves a big thank you to you first for coming. It's not easy to come on a Monday evening. There's so much to do, and all our hands are always so much full. But thank you so much for coming. I'll straight away get into the subject, and we will take the question answer at last, so that with the flow you also flow ahead. And believe you me, I'm telling you that I will leave you certainly with some understanding of the IBPI updates, and also all of them at one place, so that whenever you want, you can have a look. This presentation I have also prepared in a way which is also useful for the students, because I've always been very fond of teaching. So I've made the presentation in an elaborate manner so that you can also share it with your officers and people who are working for you. Now, what I've done is I've created a master sheet because there are a lot of them, see, there are so many of them. So what I thought it appropriate is I've created a kind of a sheet to tell you what has come. So you can just quickly have a look. So therefore, just let me tell you which are the regulations that has got amendment. So liquidation process has got amendment, CIRP process also, personal guarantors also, insolvency professionals also. So CIRP, you see the Sixth Amendment here. See, this is the Sixth Amendment at point number 2. Here, Sixth Amendment, and you also see the Seventh Amendment. I hope you saw it, Seventh Amendment. Then this the liquidation process. If you see, this was 2025, the first one, and if you see the last one, 2026. So in this 6 bullet points, you see 4 of them concerning liquidation and CIRP, two each, liquidation 2 and CIRP 2. And one is about the guarantors, and the last one in this sheet is insolvency professionals. Then we also have again CIRP Amendment Regulations 2026. Okay. Then again, liquidation process second amendment regulations 2026. Then there's this voluntary liquidation process. So therefore, 3 for liquidation, 3 for CIRP. Okay. We also saw the voluntary liquidation process amendment regulations here. If you see the third bullet, then the pre-packaged also went for a change. More or less, all of this is also because of the valuation change that has come in all of them. So I'll show you all of that. 25(2), if you see here, see, all this is some other changes, but this 25(2) changes, that is 25th February changes, is all regarding and to do with more or less with the valuation thing that we will come along and show you. And this is the bankruptcy process for personal guarantors. This is also with regard to valuation. So always remember the word valuation. The 25th of February is all 25th, I mean, the February month has quite dedicated to the changes circling in and around valuation. Then there have been certain circulars, 5 of them. So all of these are regulation amendments. Then I have come to a sheet where I'm showing you circulars. So there, if you remember that there was a circular that had come out in November 2025, where they said that you should go to the special courts. And the special courts also said, this is regarding the Enforcement Directorate attachment. And the special courts had also, the Enforcement Directorate also said that we are keen to release those attachments, provided certain words has been given in the circular, and there's a format of undertaking that has also been provided in that circular. So that circular and undertaking is dated 4th of November. Then there's this due diligence. You know that there was 29A where they had said that who is the ultimate beneficiary also needs to be recognized, etc., etc. So this due diligence, so what we have named it as, the circular is also namely given as strengthening the due diligence under section 29A, because they have also tried to understand who will be the final beneficiary and to also talk about it and mention that in the resolution plan. Okay, that is where I was saying that if the COC has approved the resolution plan, for example, before 1811, and it has been submitted with the NCLT for approval, the NCLTs are now asking for this kind of a due diligence to be given by way of an additional affidavit. So we need to know about this. Modification utility and levy of fee for delayed filing. So you know that the IBBI has very kindly allowed for a modification utility, which means they have allowed modification to the forms that has been filed with them. And of course, there will be some levy of fee for delayed filing. Then there is this format for statement of beneficial ownership and affidavit. As I was talking about 29A, point number 2 in this sheet, format has also been provided, how to declare about the beneficial ownership and what kind of affidavit needs to be given under regulation 38(3)A. And you know that for liquidation process, there has been a revised forms that has been launched. So that has happened while 5th of January 2026. Now, this is the gamut of my presentation today. I hope you're all in sync with me. I will request you to kindly just give me some of your kind attention and your valuable time so that when we go from today's session, we at least have a fair understanding. So we may not know all of them, that's not important, but we should at least know that, oh, I heard Mamta saying something about it. Let me just look up the book. So that is where I'm coming from, nothing more and nothing less. So this is first, if you remember, I want to talk about the changes that has come on the 14th of October. Okay, 14th of October, very quickly, liquidation process, Second Amendment Regulations 2025. Now, what has been the amendment? I have put it here. Now, let me just show you that how does it look before amendment, okay? And after amendment, what has happened? So what is my presentation strategy? That before amendment, I have put the thing in red, okay? Rather than having a presentation where I could show that, see, now something of this kind has come, so it means that I have picked up the Bear Act, and from the Bear Act, I want you to see the changes. Why? Because Bear Act is something which is embedded in our heads. Bear Act is something which we see day in and day out. So, something which we see every day, we are able to relate from it in a much better manner because our cognitive skills are at its best when we are looking at something again and again. So therefore, you will be able to understand this better. And then wherever there is something which needs more input, I'm always there. So what am I talking about? I'm talking of the liquidation process, okay? The pure liquidation process, not the voluntary liquidation, etc. The liquidation process. Now, if you recollect, there is a regulation called 31A, which speaks about stakeholders consultation committee. Now, before I talk about it, I want to tell you that while these changes, sale as a going concern in liquidation has been discontinued. Sale as a going concern in the liquidation process has been discontinued. First, understand this major thing. Now you will be able to relate to the amendments. So, what has happened? There were two provisions, if you recollect: sale of the corporate debtor as a going concern, and the other one was sale of the business, okay, as a going concern. Now, both of it has been stopped. So, if both of it has been stopped, then obviously the peripheral or the applicable provisions which was in and around that, in and around facilitating the sale of a corporate debtor as a going concern, will obviously have to be removed from the law books. Therefore, this regulation, the amendment to the liquidation process regulations, is hovering in and around that. Now, with that, let's listen. So, 31A, the Stakeholders Consultation Committee. Now, this committee was also, look at the third line, based on the list of stakeholders prepared to advise him on matters relating to, look at the third line from the top, to advise him on matters relating thereto. Don't worry about the him. Him includes her, her includes him. Okay, the General Clauses Act on the lighter side, to advise him on matters relating to, what is point number F? Review of marketing strategy in case of failure of sale of corporate debtor as a going concern. Now, this review need not be there anymore because, as I told you, that the sale of corporate debtor as a going concern has been discontinued. Okay, so this was before amendment. Look at the heading on top of the green belt, before amendment. Now, what it looks after amendment, look at the belt, the just top above the top green belt. After amendment, clause F has been omitted. So look, this was the clause F. Now clause F has been omitted. If you see the green stars, so it is there in the new regulation, and on the footnote it has been given that clause F has been omitted. Okay. Now, so what is it? Previously, Regulation 32 allowed the liquidator to sell assets standalone in parcels or the corporate debtor or business as a going concern. So what was this 32? 32 clauses E and F. And Regulation 32A specifically details the procedure for sale as a going concern, including creditor committee involvement, grouping of assets, auction protocols, and running the debtor's affairs as a going concern. So, by way of the second amendment, clauses E and F, okay, has been entirely deleted. So this indicates that sale as a going concern is no longer permitted under the liquidation process regulations. I hope I have been able to clarify this. Look at this 31A. Okay, 31A. Now I come to 32 because I have to come serial wise. Now 31A stakeholders consultation committee will be formed only then sale as a going concern, etc. happens. So therefore 31A I had to show you first, where we are now saying that there will be no review because sale of going concern has been stopped. So that particular clause has been omitted. Now, before amendment, clause 32, rather regulation 32 had E and F. Okay. Now, E had the heading of 32 is sale of assets. Sale of assets, E, has been now removed. So look at the after amendment here. You look at the right side of the screen. After amendment, look at the pointers E and F. E and F does not find a place in after amendment. So on top, I have written Regulation 32, clauses E to F, provision omitted. So therefore, what was E? The corporate debtor as a going concern, or the businesses of the corporate debtor as a going concern. Now, what I have done is, before amendment 32A, so we first saw, so what did we see? See, we first saw 31A, okay, then we saw 32, now we are seeing 32A. 32A was to deal with sale as a going concern. The heading of 32A was sale as a going concern. So how does it look before amendment? The whole regulation has been put here to show how it looked before amendment. Now after amendment, regulation 32A, because it was relating to sale of a corporate debtor as a going concern, has been totally omitted. Okay, so therefore 32A has been totally omitted because it dealt with sale as a going concern. Now, what is the objective and implications? I'm not going through it. I will leave it with you. But just the third line, the second amendment mark a further simplification by removing the redundant provisions and ensure regulatory clarity in sale mechanisms during the insolvency process, etc. Now, let's come to the CIRP Sixth Amendment regulations. So on 14th of October, as I was telling you, two things we were always harping on. One was the CIRP regulation changes and the other was the liquidation process. Now the CIRP regulations. So what, again, you will see that quite a lot of this has to do with the sale of a going concern. So 14th of October is quite dedicated to that. Now the amendment, this is, of course, you remember, 39C was there in the CIRP regulations. Okay, so what has happened? I've put down the amendments. Then, if you see 39C, it said that before the company is being taken to liquidation, or before, if you recollect, before approving the resolution plan, the CIRP process itself, the COC in the CIRP process had to do an assessment. Okay, so therefore, this assessment was assessment of sale as a going concern. And this was in the CIRP process. Therefore, this was featuring in the CIRP regulations. That is regulation number 39, capital C. Okay, that heading itself was assessment of sale as a going concern. Now, I'll just read one paragraph to give you a hang of it. So, this entire 39C, if you see, Regulation 39C, dealing with sale as a going concern, has been omitted. So, what was it? Assessment of sale as a going concern. Let's just read the sub-regulation 1. While approving a resolution plan under Section 30 or deciding to liquidate the corporate debtor under Section 33, the committee may recommend that the liquidator may first explore sale of the corporate debtor as a going concern under regulation Under Clause E of Regulation 32 of CIRP, liquidation process regulations, or sale of business of the corporate debtor as a going concern under clause thereof, if an order of liquidation is passed under Section 33. So, what if this happens is what 39C was all about, right? So, in 39C, as I read out in front of you, subregulation 1 was speaking about sale of the corporate debtor as a going concern or sale of business of the corporate debtor as a going concern. Now, since these two concepts has been removed from the liquidation process regulations, obviously having regulation 39C as a paraferial regulation does not make sense at all because it has become redundant. So therefore, to escape redundancy, 39C, dealing with sale of a corporate debtor as a going concern or dealing with sale of a business of the corporate debtor as a going concern has been totally omitted. Now then regulation 39 capital D, D for Delhi. Now this also, if you see, the fee of the liquidator. Now, I also want to again tell you that 39D also fell in the CIRP regulations, okay? Because what if, now that what if had to be discussed by the resolution professional before the company's resolution plan is put to or sent to adjudicating authority and put to vote before the COC, okay? Now, here the fee of the liquidator, 39D was dealing with, and in 39D, sub-regulation B, it was said that the period, if any, used for sale under clauses E and F of regulation 32 also needs to be talked about. Now, this period will not be there because E and F has been omitted from the law books, right? So, therefore, the fee of the liquidator for that period need not be discussed at all. So therefore, this is quite a valid change. If I may say, it's something which is a subsequential change or consequential change. Let us call it consequential, that it has to be done because consequentially, something which was related with sale of a corporate debtor as a going concern and sale of a business of the corporate debtor as a going concern. So wherever peripheral regulations were lying with regard to these two have to be then taken out of the law books by way of this amendment. So regulation 39D, after amendment, they have removed this B. Okay, point number B has been removed. Now, this is now I'm coming to 1410. I'm done. So 1410, we spoke about two things: removal of sale of a corporate debtor as a going concern and removal of the sale of business of the corporate debtor as a going concern. And we saw these changes not only in the liquidation process, but also consequential changes in the CIRP regulations. That was 14th of October. Now we've traveled down to the timeline of 4th of November. I'm sure we are all aware of this landmark thing that had come on the 4th of November. Why do I say landmark? Because we all are aware that not only in the Benami Act, by the use of Benami Act, but also by the use of this PMLA Act, there were a lot of these assets, okay, that were getting attached by the Enforcement Directorate's office. And because we saw that this attachment is happening during CIRP sometimes, that is, please listen to me, friends. This should you need a minute's break after each change, I can wait. But I request your kind attention. And if you think I'm going a little fast, I can slow down. Is this okay? Is the pace okay? Just
Yes,
some.
madam.
Okay, okay.
Yes, yes.
Okay, okay. Thank you so much. I'm just resharing my screen. I want you to just first understand the need, okay, and what is the change. Then I will go to the slides because that's how I like to study. Now, in this, what happened? Why do you think this was required? Now, as a lawyer, I also want to tell you because in the courts, I was also seeing, and in some of our cases also it has happened, that during the moratorium, during the moratorium, we also saw sometimes that the enforcement directorate was attaching the assets. Now, when it happens during the moratorium, we go to the respective adjudicating authorities and say that, Lordship, This has happened during the moratorium, which means it is absolutely in the teeth of Section 14. Okay, it is absolutely in defiance of Section 14, and Section 14 is laid down in the IBC Code. And since IBC Code is a wholesome law in itself, and since the moratorium provisions has been, flouted, therefore we are here before you as lordships under the NCLT IBC law, and looking at the provisions of Section 14, because it is in direct contravention of Section 14. We are not going to the special court. We are coming before your lords. We go and say this to the NCLT and we file an application. Now, a lot of times we see that we also know that there is an applicability of Section 32 capital A, where 32 capital A talks about a clean slate principle, right? And 32 capital A is very clear to say that this 32 capital A is more of an explanatory section. The clean slate principle always existed since the inception of the IPC code. So therefore, we go to the NCLT and say that Lordship, it is not only defiance of Section 14, but also defiance of Section 32 capital A. But lot of times we have seen that lot of times, I mean, I say this humbly, that Honorable Adjudicating Authority always is quite hesitant to pass orders, because also of the fact, and we need not, really tell them that why you're not doing, but because there have been multifarious such judgments in so many other cases also, where people have approached high courts, or they have gone to NCLT, and have also gone to, why I said high court, obviously, find out a judgment of a Bombay High Court. We may have read about 2 years back, there was such an important judgment where it had said that enforcement directorate does not really have should be having any leeway to attach assets when the company is already in NCLT, not attached during the moratorium, because the company is under NCLT, etc. But nonetheless, we also saw some judgments where the judgments were saying that this should be dealt with in the special court, and that NCLT or NCLT, etc., it should not be in their jurisdiction. Okay, so there were so many other judgments like this. So therefore, I am grateful to IBBI. Yes, Pradeep ji, I'll just take up the question. So the just give me a minute only. So Insolvency and Bankruptcy Board of India, they have now institutionalized a mechanism to enable the release of assets of corporate debtors that have been attached under the PMLA, with the objective of strengthening the insolvency resolution under the IBC. Now, I must tell you one thing, that I, as a lawyer, have been privy to a matter where we saw that, yes, the Enforcement Directorate released the attachment on the assets. Yes, you can rub your ears. I'm saying this. They had released the attachment on the assets, and it took about 3 to 4 months. Now, this was not by this undertaking, not by making use of this undertaking, but by approaching the PMLA court, rather the appellate tribunal, on its own. So we know that in a lot of cases, the RPs and the liquidators had filed cases in the special courts. Some moved the NCLT, some had moved the special courts. So the case that I encountered was, before this circular had come into being, the liquidator or the RP had moved to the special court, and they had got the restitution of assets. Okay. Now, through this circular issued on November 4th, so you can remember this date, it's quite a vital date. The IBPI has directed all registered insolvency professionals to file applications. So, if you see the words, the IBPI has directed, okay, all IPs to file applications under sections 8 by 7 and or 8 by 8 of the PMLA before the special courts constituted under the PMLA, seeking restitution of assets of the corporate debtors that have been attached by the Enforcement Directorate. This initiative aims to enhance the value of the corporate debtor and thereby improve overall realization in resolution proceedings. To expedite the process of releasing such assets, the IBBI, in consultation with the Enforcement Directorate, has introduced a standard undertaking that IPs are required to submit alongside their applications to the special court. Okay, standard undertaking. Under this undertaking, an insolvency professional acting in the capacity of a RP or liquidator must abide by several obligations until the resolution plan or the dissolution order is approved by the adjudicating authority. Among these obligations, the IP must furnish quarterly status reports to the special court outlining the condition of the restituted assets, the manner of their utilization, details of beneficiaries, and particulars of any sale or transfer of such property. Okay. Now, let me just show you. So these two, maybe I'll just read this. What are the key highlights? And then I'll just tell you what is actually also happening in practical. Furthermore, the framework mandates that IPs disclose all properties under the ED attachment in the IM or auction notice and update these disclosures as additional information emerges. So I'll stop here to tell you that in many of our cases, if, say, for example, your IM has already been floated before 4th of November, okay, and you may not have come across these changes which has happened on 4th of November, I urge that you should please revise your IM very quickly. And even in the RFRP, etc., request for resolution plan document, we always write about the status of the assets, etc. So there also, if your RFRP or your IM has already been floated, I request you to add an addendum to that if these details are not specifically included in your document, process document, as well as your IM. So therefore, the framework mandates that IPs disclose all the properties under ED attachment in the IM or auction notice and update these disclosures as additional information emerges. So even if you may feel that no, as per law, for the documents that I've already done, it's not required, but from all angles, I humbly tell you that you must do this. The insolvency professional is also required to provide full cooperation to the Enforcement Directorate during ongoing investigations, including furnishing information on preferential, undervalued, fraudulent, or extortionate transactions whenever identified. Additionally, the IP must supply details regarding the constitution and voting shares of the COC, as well as information concerning the SRA, together with relevant applications and orders of the NCLT. Okay. Now, this I'm sure you're aware that what would be the objective and implications, of course, to have a greater value to the assets, because whenever there's an ED attachment, we know that never a full potential of the valuation is ever achieved, and people seldom come forward to buy those assets. So I think it has been a very important change that has been brought forward. Yes, I have two hands, I think, which has been raised, one by Pradeep ji and one is by Raghavan ji. So you may please ask your questions. But before you ask me questions, I want to give you a fine line of difference, One matter had come to me for opinion, where I was seeing that, say, for example, any attachment had happened while the process is under implementation. Okay. Now, it may so happen that as per this circular, if the attachment has happened during CIRP or during liquidation process, you can make the use of this circular. Now, in a case, the attachment has happened while the implementation was on. Now, as per this circular, exact wordings of the circular, one cannot approach the special court because the language of the circular, read with the language of the undertaking, denotes that RP and the liquidator, okay? Plus it says CIRP or liquidation. So if you saw resolution plan, you also heard the word dissolution, etc. But it so has happened in a case where the attachment has happened during the implementation. Now, where the RP has become the erstwhile RP, liquidator definitely is not there, and CIRP is not on, neither the liquidation is on. So can you make the use of this circular? So once if you read it critically, it's understandable that you cannot make use of this circular. But when the matter has traveled high courts also, because high court was already on, there was a writ petition. In that, the high court has mentioned that please, you may like to approach the special court, because the enforcement directorate comes and says that no, this circular is there, and let the RP not come to any special, not come to any other forum but the special courts. So sometimes what I also want to tell you by this is that at times the language of the circular may be limiting, but when practically we do things, one has to probably stretch its own understanding. Okay, with this, I'll now give it to Pradeep ji first. Yes, Pradeep ji.
Madam, with these changes, in the present situation, still the ED has a right to attach the property during the moratorium, or they have all stopped it after this? Uh,
No, they haven't stopped it. I'm sure
oh,
they haven't stopped it.
they
So,
are still attaching it as an IRP. I should file an application to the special court and get it released. Correct?
yes, yes, sir, yes,
Their duty
yes.
they are doing. Our duty we will do it.
Yes, yes, because they
Okay, madam.
sometimes they fear that
Uh,
these the assets have been by way of Binani transactions or by routing unnecessary the money from different sources, which is not correct, etc. So they are still doing their duty, and we have
uh,
to do ours.
Okay. So this is one extra job for the IRP to give that quarterly report to the special court also going forward.
Yes, if you are invoking the special court, if you are
Ah,
invoking the special court for the release of the attachment,
release of the property.
only
Ah,
then.
ha, 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 ha.
So I think which is
Okay.
a fair ask, because they would like to also keep themselves informed that for the benefit of the COC, if the release of assets has happened, so it should actually then be used for that purpose only. So I think like the adjudicating authorities asks from us progress reports,
Okay.
it
Okay.
may be it may be considered as a fair ask to my understanding that they should be kept aware as to what is happening with the assets.
Is it any separate report to be filed for the NCLT for this? For this, any other special like what we do for
No,
the other report?
no,
No, only
no.
for the special court we are intimating this one.
Yes,
The
and
report.
in your progress report, anyways, that you keep
Ah,
filing with the NCLT, you can dedicate a portion of your progress report
ah.
towards. You
There
should
also
do
I'll
that.
disclose it.
Yes, yes,
Okay.
always,
Okay.
always.
Okay. Okay,
Even
madam.
never, you should never. See, I'm giving you my experience. Sometimes people say, oh, my progress report is unnecessarily becoming very long and bulky. It becomes difficult to file. Oh my God,
Ah,
it's 2 volumes. Let there be any number of volumes. Okay.
okay.
Never be a, never get into the miser box when you are doing reporting to a regulator. You should always do it wholesomely, is what
Yes,
my
madam.
experience has been.
Okay, madam. Yes, madam. Yes, madam. Got it, madam. Thank you.
Yeah, pleasure. Any other question? I had a hand raise. Okay, so now let me move forward to, so what we did two dates, 14/10, then we did 4/11. Okay, so we did October, we did November. Now in November, after 4/11, there's also this 18/11. Now let's see what is that. 18/11 is about the due diligence, okay? It's strengthening the due diligence. If you recollect, I had told you about 29A in the beginning, that if, so should I give you a break? Okay, we'll just take 1 minute break because I want this to be synced in. So what did we do? We did 14/10. Okay, in 14/10, we spoke about the redundancy of sale as a going concern, sale of the corporate debtor as a going concern, and sale of businesses of the corporate debtor as a going concern. So 14th of October was all about that. And if your case is under liquidation, then also you need to know this. And if you are a RP, then also you need to know this. Why? Because if you are an RP, then regulation 39C and 39D has also gone for a change. Okay, so therefore, as an RP, you need to know this. And if you're a liquidator, of course, you need to know this because these two, E and F, has been removed from the law books. So you should not be invoking sale of corporate debtor as a going concern, and you should not be invoking sale of business of the corporate debtor as a going concern. So this was 1410. Then we looked at 411. What was 411? 411 was about enforcement directorates, IBPI taking steps and saying that we should approach, directed the RPs or IPs rather, to approach the special court if there has been any attachments of the ED during the CIRP or during liquidation. Okay, and they also talked about a format of undertaking, etc., which I had also shown you in my master sheet. Okay, so we did 2 dates. Now let's go ahead and do the third date, which is 1811. Now, very quickly, this is all about 29A. As I was telling you, that 29A was about you're aware that 29A is all about the due diligence of the buyer, and they would always want that no unscrupulous player, okay, no unscrupulous person should get into the ecosystem. And that is how this 29A has been further strengthened. So, what is that? See, okay. The new directive adds a mandatory procedural step. What is that? RPs must now place a detailed note on Section 29A compliance before the Committee of Creditors at the time of evaluating resolution plans. Now, this is the first change that has come. What happens today in the present moment is sometimes I'm sure we're all very, very experienced and we take due care, but sometimes in the minutes, we just write that 29A was placed and the COC took note of it. Okay. But now what is it that they are saying? For example, if you see the NAFRA circulars, I'm just trying to draw analogy. If you have seen the TCWG change that has come in the corporate governance, that those charged with governance concept has come in the Companies Act. I'm sure you may have seen it. There also they are focusing so much on the minutization as to how you are minutizing the things. Similarly, nowadays ministry is also becoming very careful and asking us that whenever you are doing any discussions in the COC or in the wherever the committee, you should minutize it well. You should show an application of mind. So, for how will an application of mind happen with a short note? It cannot happen. So, therefore, now it has been said a directive. Okay, see the words. A new directive has been added in the 29A, and they say that RPs will now have to place a detailed note on Section 29A compliance before the COC at the time of evaluating the resolution plans. Not, please mark my words, each of my words has a meaning. What have I written at the time of evaluating? I could have written, I means the law could have written at the time of voting of the resolution plans, but it's not written that way. It is written at the time of evaluating the resolution plans. So you have to mark those words, okay? Then RPs must also ensure that all deliberations and observations of the COC on Section 29A compliance are fully and accurately recorded in the minutes of the meeting. So I just wanted to tell you that these are not my words. Okay. So you have to please take care that RPs must also ensure that all deliberations and observations of the COC on Section 29A compliance are fully. Now, please note that they could have just written accurately, but they have also used the word fully, are fully and accurately recorded in the minutes of the meeting. Okay. Now see, these are the changes that has also come. Okay. Now, what are the key highlights of the circular? If you want to just see, The circular emphasizes that due diligence under Section 29A is paramount and mandates that RPs undertake enhanced scrutiny when examining the resolution plans. While the code and the IBPI regulations already impose several duties on the RPs and PRAs, such as, see, these are already there. Okay, what are there? I've also put it down here. Regulation 36A4, Regulation 36A7, and so on and so forth. Okay, these are already there, is what I'm saying. Already there. Now, even this being there, this, okay, key additions, while clause 4 of the circular has been now added. So, what I'm trying to show you is that we already had this. This is my input. We already had this. On top of it, now we have to have this too in your work to do while you take care of 29A. Okay, I hope I've made my point. So, what was the date? 18 of November 2025. And all these are effective immediately. Okay. Now, what are the objective and implications? Of course, as I told you, ensure that only bona fide applicants remain in the contention. Now, next, let's go to 2011. I will close sharp at 6. We have begun sharp at 4:30. So let me just take you through, and then if we have time, we'll again go back to do a detailed analysis. Okay. Now, I'm still trying to make it detailed, but still. Now, this is 2011-2025. This changes has come in the insolvency resolution process for personal guarantors to corporate debtors. Now, this amendment introduces a new regulation. What regulation number? 23. What does it do? Read the fourth line, which sets out mandatory requirements relating to the filing of forms by resolution professionals. So, if one is a resolution professional acting in a personal insolvency case, then one has to do a lot of filings. And who is this one that I'm talking about? Is, of course, you and me, the resolution professionals. They have to do the filing of forms. Okay. What are those? Now, this is in green. So, whenever you are referring to my article or to my presentation later, please remember green is a new addition. And whatever you see in red, that is before amendment, which has now become redundant. So, green is something which is here to stay. Now, very quickly, Regulation 23 has been, and please mark this date. So, if you still haven't started doing it because you were not really aware of it, doesn't matter, please start it now. If you see the last line, they shall come into force on the date of their publication in the official gazette, which has happened. So it is always whenever the day whenever you see this date, okay, this is a date when it is already becoming applicable. Now, what are the filing of forms? The RP shall file the forms along with enclosures as per the timelines. The board shall make available the forms on the electronic platform. And number 3, the RP shall ensure that the forms are accurate and complete. And point number 4, the filing of the form after the due date, whether by correction, shall be accompanied by a fee of 500 rupees. Okay, after the due date, otherwise there is no charge. And point number 5, the resolution professional shall be liable to any action if if there is a failure of form or if it is incomplete or inaccurate or delay in filing the form. Okay. Now, if you see introduction of regulation 23, now this is what I was talking about in the green. I've just laid it down here. So these amendments are intended to improve the quality and timeliness of data, and they aim to ensure greater accountability. Okay. There are these forms you may have to, file. Now, then I want to talk about this IBBI Insolvency Professional Regulations 2011-2025. Now, what is this? The new regulation imposes assignment limits on individual insolvency professionals to ensure effective case management and maintain the quality of insolvency administration. What is this? Now, I'm sure we are all aware of this change at least. So, in November, we saw two we have already seen. This is the third. What were the two? Very quickly. 411, we have seen 1811, we have also seen 2011. So we've seen three, now we are seeing 2011. In 2011, what we are seeing, so this is the fourth change that we are seeing. In the fourth change, we are seeing changes in the insolvency professional regulations, where they have inserted a new provision, Regulation 7B, immediately after Regulation 7A. Now, this, what they have done, they have introduced 7B, where they are talking about number of assignments. Anyways, we had the heading for 7. The 7B has been introduced. Let me read it for you. I'm sure you're aware of it, but still, an insolvency professional who's not an entity shall not at any point of time have more than 10 assignments in aggregate as IRP and RP in a CIRP and as a liquidator in a process of which not more than 3 assignments shall have admitted claims exceeding 1,000 crore rupees. This is similar to a change that we have, this is similar to a provision that we have for independent directors, kind of independent directors. If you remember, they also have that we cannot be in more than 7 companies as independent directors, etc. And so these are the limits, which has been given. Similarly, here, provided that an insolvency professional who is not an entity, just give me a minute. So an insolvency professional, so as I was telling you, of which not more than 3 assignments shall have admitted claims exceeding 1,000 crore rupees each, provided that an insolvency professional who is not an insolvency professional entity already holding more such assignments than the limit specified in this regulation shall not accept any such new assignment until the number of his ongoing assignment falls below the limit specified in this regulation. So if somebody has maybe more than 10, 15, 20, whatever, they can still continue, but cannot then accept new assignments unless they fall within this limit.
Ma'am,
Okay?
is this include the assignment related to personal guarantor?
No, it is not.
Mm,
It
Okay.
only talks about CIRP and liquidation. That is very, very specifically given.
Okay. Thank you.
Okay, thank you. So I have these slides. I have more, once, 2, 3 times if we read a particular thing, only, it helps us to understand more and also helps our juniors to, understand it better. So with that concept, IBBI Laws had also requested me that let it be a detailed presentation. So like here, you can see and understand point number 1 and 2. But if somebody reads this slide again, it is a reiteration of what has been given here, but then it just helps us to get a clarity. So therefore, I have divided the slides into like what are the key provisions. Then I've also have a slide on what are the objective and implications, etc. So you may, when you start reading on your own, you may skip these slides. Okay. Now, so we are done with month of November. Okay, now I'm since already a revision has happened for the month of November, I'm straight away now coming to the month of December. Okay, now what has happened in the month of December is more so with regard to the forms have been given a modification button. Okay, so if you read after the paragraph begins, just read the first bullet. Introduction of a modification utility for CP forms filed on the IBPI portal. Commencement of levy of fees for delayed filing of forms. Okay, these measures aim to improve data accuracy, regulatory compliance, and timeliness of disclosures by insolvency professionals. So this is something which it's more technical in nature. So the fee applies to all forms that were due on or before 31st December 2025, but are filed after that date, thereby bringing past delays within the fee framework. And I told you fee of 500 rupees. Effective date is the fee requirement is applicable to all eligible delayed forms filed after 31st December, while the modification utility is available for immediate use. this is quite a good thing. If you recollect, sometimes, by mistake, something just used to get filed and we used to struggle, we used to write to IBPI, then they used to activate some button and we again used to refile it. So I think, they have done away with this and they have introduced the modification utility. So thank you to them for hearing us and doing this. So from January 2026 onwards, delayed filing of CP forms under Regulation 40B carries a financial cost, while the newly introduced modification utility provides a structured mechanism for correcting deficiencies in filings. Now so which was this date? Let's go back and see, 18/12. So in the month of December, we are towards the fag end of December. So 18/12, and here we have another change just after 3 days, that is on 22/12. Now, what happened on 22/12? See, there is a CIRP 7th Amendment regulations. Okay, what is the regulation change? The amendment inserts sub-regulation 3A in Regulation 38. Now, you know that Regulation 38 is very, very important whenever a resolution plan comes to us and whenever a resolution plan is heard in the Honorable NCLT, and whenever you have to give a certificate that the resolution plan has all the compliances. So Regulation 38 plays a very, very pertinent role. Now, what has happened in Regulation 38? So look at the green box here, before amendment. So what is the heading of Regulation 38? Mandatory contents of the resolution plan. Okay. Now, in that mandatory contents of the resolution plan, after sub-regulation 3, what was sub-regulation 3? Sub-regulation 3 was a resolution plan shall demonstrate that it is feasible, viable. Remember these things, I'm sure, that it addresses the cause of default, etc. After that, a new sub-regulation has been added, which is sub-regulation number 3A. What is that? Every resolution plan shall include. What is that? If you recollect, I told you in the beginning also, a statement of beneficial ownership in a format. I'm reading it very slowly because it's very, very important. And as I read, I must tell you that even if a resolution plan has been submitted before the Honorable NCLT for its approval, and this amendment has come on 22nd of 12th, December, but your resolution plan has been submitted, for example, before the NCLT in the month of October or November, even then, the Honorable Adjudicating Authority needs to be submitted with this kind of an affidavit by way of a supplementary affidavit. This is what we have been doing it here in NCLTs, and sometimes the judges are also asking for it. And even if they are not asking, you may like to do it as an additional compliance. That I'll leave it to you, but I'm just saying the practice that I'm seeing it in so many NCLTs. So every resolution plan shall include a statement of beneficial ownership in a format to be notified through circular. As I told you in the beginning, I had shown you that circular has also been notified by the board, covering details of all natural persons who ultimately owns or controls the resolution applicant. So, for example, the resolution applicant is ABC Company Private Limited. So you have to track it down as we used to do for BEN forms, beneficial ownership forms, same thing. So who ultimately owns or controls the resolution applicant together with the shareholding structure and jurisdiction of each intermediate entity. And an affidavit in a format specified by the board, which I told you has already been specified, that the resolution applicant is eligible or not eligible for the benefit of Section 32A. So, sometimes, when the resolution applicants who have come forward and given the plan, they have failed in, say, for example, in another resolution plan. So therefore, or they are the promoters or not allowed, or they have come by a backdoor entry, etc., etc. So it's more of a kind of a, we know that of course they are 32A eligible and that is why they've become the resolution applicant, but one has to now also write it in black and white. So as we know that we all have to be honest, sometimes in code of conduct there are these statements given that I will be honest to my duty, etc. Though it is an inherent and embedded law that one has to be honest. Similarly, certain things in such amendments, we are seeing that some things which are definitely apparently and has to be there, those have to be written also. So what is it that I'm saying? That on 22/12, okay, there has been an amendment by way of introduction of sub-regulation 3A in regulation 38. Okay, now this sub-regulation has been, of course, brought into effect from 22nd of 12, I mean 22nd of December. But as I told you about the practices, I've already mentioned. So I hope you got this clear that the format for point number A, 38A, 3AA is already being notified, and also the format of the affidavit has also been specified by the board. Now, what are the key changes? I'll just read this and then we'll hop over to the next changes. The amendment mandates that every resolution plan must include a statement of beneficial ownership in the format to be specified by the board, disclosing the natural persons who ultimately own or control the resolution applicant, along with the shareholding structure and jurisdiction of each intermediate entity, and an affidavit stating whether the resolution applicant is eligible or not eligible for the benefit of Section 32A in the format prescribed by the board. Okay, the objective is to instill governance from the start, and in the process trying to make sure that there is no backdoor entry of the ones prohibited under Section 29A. Now, so we saw 18/12, we saw 22/12, and now we are seeing 29/12. Okay. Now, this was, if you recollect, these are here we spoke about these circulars and the format. All that has come out on 29/12. Has issued a circular prescribing standard formats for the statement of beneficial ownership and the affidavit to be furnished under Regulation 38, Sub-regulation 3A. Now look at the sub-regulation 3A. It has not written 3. So 3A has been written of the CIRP regulations, and the measure aims to strengthen transparency, disclosure, and due diligence in the CIRP. I hope you've been able to get this. Okay, now we'll just take a okay. So this is the same thing, that the implications, etc. And IBBI has, what are the objectives? IBBI has mandated standard formats for the statement of beneficial ownership and affidavit under Regulation 38A. Okay, these disclosures must be submitted along with the resolution plan, placed before the COC, and filed before the adjudicating authority under Section 30, Sub-regulation 6, making transparency and ownership disclosure a core component of the CIRP framework. Now, you may ask me a question that, ma'am, when already a resolution plan has been submitted before the adjudicating authority, how can it be now placed before the COC? Okay, but I think you can still place before the COC because there has been a change in law. You're aware that until the resolution plan passes the muster of the adjudicating authority, the COC exists for only the specific few things. So you can still, circulate this with the COC and then file it as an additional affidavit. That I leave it to you. Yeah, I'm just telling you the practice. Now I will kind of, I think, take a small break here, and then we will move on to the month of January. So here in the month of December, I think we spoke of few critical things. We spoke about strengthening the due diligence, okay, where we said that in 29A we'll have to, do certain additional things and make sure. What were those? That a detailed report of the 29A due diligence needs to be put up before the COC, discussed, and fully and accurately recorded in the minutes of the COC. Then we also saw the changes in terms of filing of forms. Then we also saw about the modification button. And then lastly, we also saw about the 29A beneficial ownership formats and the provisions that has been introduced. So December, you can more or less dedicate to 29A. Okay, more or less dedicate to 29A and the forms. Now let me just move forward. We will now move forward to the month of January. Now, in the month of January, if you recollect, we were discussing that again, the CRP and the liquidation process regulations had also changed. So what happened? Now, in the month of January, when was that? Second, the January just clocked its calendar, changed, and immediately we saw this change on the 2nd of January. What is filing of forms? The liquidator shall file the forms along with the enclosures thereto on an electronic platform of the board as per the time stipulated against each form as per the table below. This was before the amendment, okay? This was before the amendment. Look at the heading before amendment. We are talking of Regulation 47B. Now, what happened after amendment? The liquidator shall file the forms along with enclosures thereto as notified by board from time to time on an electronic platform of the board, okay, as per the timeline stipulated for each form. So this is the change that has come. So by requiring electronic filing of board notified forms within prescribed timelines, the amendment standardizes the submission process and integrates it with the board's electronic platform. Okay, so electronic platform was integrated with. Now, what happened on the 5th of January? There were these launch of the revised forms for the liquidation process. The IBPI has launched revised liquidation forms for the liquidation process. How did they do it? Through a circular dated 5th of January with the objective of streamlining the filings and reducing compliance burden on insolvency professionals. The revision follows amendments which mandates insolvency professionals to submit liquidation related forms on the board's notified electronic platform. Okay, so 2nd of January, we saw that the forms needs to be filed electronically, and those forms which needs to be filed electronically also got notified on the 5th of January 2026. So discontinuation of existing forms is the key highlight. As per the circular, the existing LIQ forms have been comprehensively revised and shall stand discontinued with effect from 1st January. From this date onwards, only the revised forms will be accepted for filings relating to liquidation proceedings. So there was some relief during the transition period. What is that? This is very interesting. To facilitate a smooth transition, IBPI provided relief to insolvency professionals by waiving penalties for delayed filing of revised forms during the initial quarter from January to March. This grace period is intended to help professionals familiarize themselves with the new formats and address any technical issues. So I'm requesting that IBC Laws also, wanted to do this session just before the close of March, so that if in case we have just missed out, just in case if we have missed out this circular, we may kindly make the best use of it. Okay, so I just hope you have been able to look at this presentation. Now, so what did we do in January? We in January spoke about two changes. One was of 2nd of January and the other one was of 5th of January. So we spoke about the forms. Okay, 1st of January, I mean, the January clocked its calendar on 1st of January. 2nd January, we saw a change that electronic platform will be provided for the filing of forms in the liquidation process. And on 5th, all those forms also got notified. And they also provided a window from January to March 26 to say that as a smooth transition, you can file the forms without a penalty. So now we are jumping on 25th of February. This is where a lot of changes has come, but it looks very overwhelming, but it is not. So I know we are also probably kind of a little tired because you're listening for the past 1 hour, 10 minutes in continuum. But I'm requesting you to please hear me out on this because if I want to tell you in a very easy manner so that it will remain with you. I want to first tell you the concept. Okay. Now, if you see my slide, And if we understand the first, what are the changes that has been brought in the CIRP with regard to valuation, similar such changes have been carried out in the other regulations as well. So we may just listen to one. A lot of other slides will then just be a kind of a continuous understanding of the same thing. Okay. So on this 25th of February is quite an important date which one has to remember, because if you are into the process, and even if 25th of February has gone by, I'm telling you, a lot of these in this process, people are still going ahead and making changes in the way they are carrying out liquidation. Sorry, in the way they are carrying out the valuation. Okay, so that is of course for you to discuss in the COC, but that is how I have been looking at the documents when I appear as a counsel in few cases. What is the changes? They are introducing key changes relating to valuation methodology and treatment of certain stakeholders in insolvency proceedings. Now you first remember the valuation. Okay, now let me give you a prelude. We know that in valuation, what are we following today? We are following the international rules of valuation, right? Now IBBI is saying that I will give you the rules for valuation, and will also tell you how the format of valuation should be. Okay, the format of the report should be, just एक बार मोटा मोटा समझ लीजिए. So they are saying that we will give you the rules also, we will also tell you how the format should be. And thirdly, they are also saying that we would like to also, I mean, IBPI is saying that we will also like to kind of give you something more to do with fair value. Because why? Because sometimes, we understand that the resolution plan amount hovers around the fair value or maybe the liquidation value, but fair value, enterprise value is also very important. So the IBPI has introduced few concepts of valuers. Okay, chief coordinating valuers. I'll show you the concept. So, and they also say that we know that there are two sets of valuers that needs to be appointed, right? If we are not appointing an RVO, so we appoint one land and building, again we appoint one land and building. We appoint one SFA, again we appoint one SFA here. We appoint PNM, we also appoint PNM here. So we appoint two sets always, right? So they have now introduced the word sets. So all these kind of changes have happened. I hope you've understood as to what I was wanting to say. Now I want your kind attention. Just give me 5-10 more minutes, 10 minutes more, and we'll be sorted. So before amendment, fair value was whatever you are seeing it on the screen. Now they say fair value means the estimated realizable value of the corporate debtor. Okay, so please understand the concept of enterprise value. Here it was only the assets of the corporate debtor. See, I've done it in a way that I've done it in track mode so that it is easily, quickly comprehensible. So fair value means the estimated, in the green that you see is the addition. Fair value means the estimated realizable value of the corporate debtor they have included. Okay, or the assets of the corporate debtor as the case may be. Now, what is the explanation? The estimated realizable value of the corporate debtor shall be computed after taking into account the total estimated realizable value of all the assets of the corporate debtor, including but not limited to tangible and intangible assets, along with their underlying synergies. So, there were some cases where there were trademarks, there were copyrights, there were patents, and we know how important these are. Okay, there were these, could be some formulas, okay, could be some technology, okay, some people could be having some information, I mean, so much data. Data is also an asset. So sometimes, they were not really finding a good sense in the valuations, and therefore the valuation was really getting very deteriorated. So therefore, this kind of a change has happened, that the valuer is now specifically being asked that not only you are going to, value the assets of the corporate debtor, because sometimes, in the balance sheet, you were not finding them as assets. So sometimes the valuer was not taking them into cognizance or taking them, or even they were not even coming to know about it probably. So now it has been made very categorically clear that the estimated realizable value of the corporate debtor shall be computed after taking into account the total estimated realizable value of all the assets of the corporate debtor, including but not limited to tangible and intangible assets. The whole green thing has been added, okay? Not limited to tangible and intangible assets, along with their underlying synergies. So, for example, in derivative contracts, we always have these underlying, okay, there's always an underlying asset. So I'm just trying to explain you the word. So there's these underlying synergies. Now, see, liquidation of the corporate debtor. Now here they say of the corporate debtor has been removed because anyways it is of the corporate debtor. Here they have included two sets of. As I was explaining you, that two sets has been included. Now, here, let's read the after amendment. The set of registered valuers appointed under Regulation 27 shall comprise of one registered valuer for each asset class of the corporate debtor. And within each set, one registered valuer shall be designated as the coordinating valuer for that set by the RP in consultation with the committee for computation of the fair value of the corporate debtor. So the the coordinating valuer will have, so for you have understood about two sets, one set three, a stack of three, the other set stack of three. Now they're saying in the first stack, you have to have a coordinating valuer. You have to appoint a coordinating valuer. So amongst these three only, you have to appoint a coordinating valuer. There will not be a fourth set. Okay, amongst these three, you have to appoint a coordinating valuer. For example, if you have 5 independent directors, these days people appoint a lead independent director, right? Similarly, this concept of coordinating valuer has been introduced in this law, and they are saying in one set, appoint one coordinating valuer from amongst the three. Here also, from amongst the three, just appoint one coordinating valuer. Okay, you do this, and when you appoint, the RP has to appoint in consultation with the CUC. Up to here, it is clear. Now, what is this coordinating valuer going to do? Coordinating valuer, look at that. Coordinating valuer will be there for computation of the fair value of the corporate debtor. Okay, not the liquidation value. So coordinating C shall be designated as a coordinating valuer for that set in consultation with the committee for computation of the fair value of the corporate debtor. Now, what is the explanation? Then there is this asset class, etc., which has been given. It's not so important that you can see it. I hope your asset class has been defined in the registered valuers and valuation rules. The definition of asset class has to be still taken from that rules. So now there has been consequential such changes. What has happened in Regulation 35? Now, if you remember that there are two things what I want to tell you, that if there are a huge gap between two valuations, one has to appoint a third valuer, right? That change I will come to you when you need to appoint. But before that, there's been an amendment where they say that the resolution professional shall facilitate a meeting wherein the registered valuers, including the coordinating valuers, shall explain the methodology being adopted to arrive at the valuation, to whom they will explain to the members of the committee before computation of estimates. So what is happening today? The whole report is ready and then we go to the COC and place the report, isn't it? But here they are saying that before the computation of estimates, okay, the resolution professional will have to facilitate a meeting. It's a shall. So we'll have to facilitate a meeting wherein not only the registered valuers, but of course the coordinating valuers also, who are amongst the registered valuers only, they shall explain the methodology to the COC that has been adopted to arrive at the valuation. So this is a very important change. And then there's one more change that has come, which I was telling you. This slide we may read because this will give you a fair understanding, and then we'll go to the next amendment. Each registered valuer shall, after physical verification, submit to the RP and the coordinating a report on the fair value and the liquidation value computed in accordance with such valuation standards as notified by the board through circular. As I was telling you, such valuation standards. Otherwise, what we were looking at the valuation standards as given in the valuation rules, isn't it? But now they say with such valuation standards as notified by the board through circular. Today, we were looking at the international valuation standards, correct? But now they say that as notified by the board through circular, etc. Okay, and C point number E, the RP may appoint a third set of registered valuers for submitting an estimate of the fair value and the liquidation value computed in the manner where the two estimates of fair value or liquidation value are significantly different, and or the committee proposes to appoint a third set of registered valuers for reasons to be recorded in writing. So it may so happen, for example, that we know that significantly different has been explained here, you know, that 25% or more. But even if, say, for example, the difference is just 20%, for example, and the COC still wants that there should be a third valuer, then also we are mandated to appoint, just that the reasons has to be given in writing as to what has been the need to have a third valuer. And look at this, a registered valuer shall prepare the valuation report and maintain such documentation as per the format notified by the board through circular. So these regulations are also very important for the valuers. Okay, and then there have been a change in the information memorandum, that in the information memorandum, what are the other things that one has to include. That is why in the beginning, as I was telling you, that even if you have taken out your information memorandum before the onset of these changes, before this amendment has kicked off, even today, it's advisable that if your process has not got completed and has come to a stage of a resolution plan, which has been put to vote, I still feel that one should come out with a addendum to the information memorandum and an addendum to the RFRP. That's completely my way of doing things. I am not here to give any legal advice, so please don't take any such legal advice from the IBC Laws Forum and neither from my side. It's just the best practices that one may follow. So these are the changes that has come in the information memorandum. If you see before amendment, you can see the heading information memorandum, and new clauses has been added, double A, AB, ABC, AC, A, and all that has been added. Okay, so one has to take care of these also. Then in the mandatory contents of the resolution plan, there has been a very, very critical change that has come, especially with respect to real estate project. Now, what is it saying? If I can just give you an overview of it, is that there could be in the real estate project there are home buyers. So this has come to rescue the home buyers. That a lot of time home buyers are not there, so sometimes they are so I mean not so legally guided, and they may not be able to afford such legal guidance also. So a lot of times it has been seen that the home buyers are unable to file their claims on time, etc. But the balance sheet of the corporate debtor anyways knows that who are the number of allottees, etc. Obviously, that data point is very much there with the insolvency professional through the erstwhile directors of the corporate debtor. So they say that if that has been recognized, then the information memorandum should include the details of the allottees who have not submitted their claims. And the resolution shall provide for treatment of such allottees. Okay, so this is very, very critical, especially for the real estate CIRPs. Now, if you see, the liquidation process regulations also has the same kind of changes. Okay, if we have understood CIRP, same kind of changes have been introduced in liquidation and also in voluntary liquidation. See, I have put it in green. You may like to see it later when you see, and also in prepackaged. It's all about the valuation. Okay, all about the valuation. All about the valuation. So 25(2) is very critical, and you may like to remember it's quite about the valuation. Then on 25(2), even if you see the bankruptcy process for personal guarantors, see such valuation standards as notified by the board through circular. And previously in red that you see, it was in accordance with the internationally accepted valuation standards. These valuation standards are yet to be notified by the board. It will, I'm sure, must be on its way. So I hope you have been able to understand the valuation concept, very, very critical. And on 6th of March, that's the last date. So this is for personal guarantors, the progress that is happening in the personal guarantor space CIRP of not CIRP, I'm sorry, Insolvency IRP, Progress of Insolvency Resolution Process for Personal Guarantors. This also now has specified electronic forms. So introduction of PGIRP electronic forms. Okay, now all forms have been notified, and these are the forms PGIRP 1, 2A, 2B, 3, 4, 5, 6. Now all that are electronic reporting forms now, and one has to do it electronically. So thank you very much. I'm done with my presentation. I hope I have been able to give you a fair understanding and through the IBC Laws platform. And I'm happy to again mention that I will share this presentation with IBC Laws, and they may like to take cognizance of it and may like to do whatever they want to do with that. So I am very grateful to all of you. If you would like to put on your cameras for a while, we may.
Thank you so much, madam. Thank you.
Thank you so much, madam.
No, my pleasure. Thank you so much. I hope I've been able to do justice to your valuable time.
Absolutely, madam. As
Definitely, ma'am,
always.
definitely.
Okay.
Thank you, ma'am.
Thank you. Thank you so much. Have a nice evening.
Yes, madam. Thank you, madam.
Thank you, sir.
Thank you so much, ma'am.
Thank you. Everybody's asking for the PPT. As I say again, I'm going to share the PPT with IBC Laws by tomorrow morning. So post which it is their property, they can share it with all of you. And anyways, I think IBC Laws always puts forward everything on their website. So you may also like to visit their website. I'm quite with them from the beginning, and you may also like to subscribe to IBC Laws is what I can say.
Yeah. Thank you, madam.
Okay, thank you. Bye-bye. Bye.